Officer Day, would you open the courtroom for us, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone.
Mr. Beach? Good morning, gentlemen.
Good morning, Your Honor.
We are on the record calling case 07-157-353 LVNV funding versus Jermaine Cooper. Date and time for objection to garnishment. Your appearances.
Good morning, Your Honor. Michael Beach, BEACH, P45459 for the plaintiff.
And what is your name, sir?
Jermaine Cooper.
Okay, hang on for just a second, gentlemen.
Let's start all over. Okay, good. Can you hear me, Judge?
I can hear you. Open.
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. We need to call IT. Apparently, we have a problem. Every time I log on initially, it knocks off the court, but we can fix that. Anyway, gentlemen,
Yes,
this
Judge.
is 07-157-353 LVNV funding versus Jermaine Cooper. Mr. Cooper, you filed an objection to garnishment. What is the basis, sir, of your objection to garnishment?
Yeah, I was in prison. I don't even know where none of this came from. I don't know nothing about this. I have something here where they said that they personally served me on 1/30 to January the 30th, 2008. That's impossible. I went to prison in April of 2007. Didn't come home until July 27th, 2021. I sent the register of actions in. I let them know I didn't do any of this. I got everything that they said that I possibly could have paperwork that I could have received or anything. I don't know nothing about this at all.
Mr. Beach.
Yeah, Your Honor, obviously I don't know the circumstances of where Mr. Cooper was some, 15 years ago. But in any event, Your Honor, this is a garnishment objection. The court rule MCR 3.101 sub K specifically states that the garnishment objection can't be used to attack the underlying judgment. And that appears what the defendant is asking the court to do today. So for those reasons, we're asking that his objection be denied. He has other recourse, different motions, but the garnishment objection is not the proper way to put forth his claims, I guess.
Yeah. Okay, Mr. Cooper.
Yes, sir.
The Michigan Court Rule 3.101K specifically provides you cannot use the objection to garnishment to challenge the validity of the underlying judgment. That's what you're trying to do here. So excuse me.
Okay.
That's why I was talking.
Okay.
So your objection to garnishment must be denied. You have an absolute right to appeal my decision. You have 21 days to do that in the Wayne County Circuit Court. If you want to file a motion to set aside the judgment or something like that, that's a different motion and that's not before the court. If you want to do that, you have an absolute right to do that. And in that motion, if you decide to file it, you should provide all the supporting documents that you have. But you cannot use the objection to garnishment as a method of saying there's something wrong with the underlying judgment, which is what you're trying to do.
I don't. Are you done, Your Honor?
I'm done.
The reason why I don't understand none of this. Like I say, I just did 15 years and the address that they use, and I haven't even lived there. So
Let's stop right here and let me
okay.
make sure that you're not understanding what I'm saying.
I'm not. I'm being honest with you.
Good.
I really don't understand what
And
you're
let's
saying.
engage our ears and disengage our mouth.
Okay.
You have filed a motion to set aside an objection to garnishment. That is the only motion before the court. One of the rules that governs objections to garnishment is Michigan Court Rule 3.101K, which specifically provides that you cannot use the objection to garnishment as a method to challenge the validity of the underlying judgment, which is what you're trying to do. So your objection to garnishment must be denied. If you want to file another motion to set aside the judgment, or for some reason, you had a right to do that. But that is not before the court today. So your objection to garnishment must be denied. As I indicated, you have 21 days to file or perfect your appeal in the Wayne County Circuit Court. If you want to file some other type of motion, sir, to attack the validity of the underlying judgment, to set it aside or have it modified or whatever you choose to do, you have a right to do that. But I can only rule on matters that are before me today. And the only matter before me today is the objection to garnishment. And the court rule specifically says you cannot use the objection to garnishment to do what you're trying to do. So we'll send out an order denying the objection to garnishment. I look forward to your motion to set aside the judgment. Thank you both for coming in. We're off the record.
I
Thank
don't
you, Your
understand though. I don't understand this. I don't understand nothing. I don't understand none of this stuff that you're telling me. Like I'm literally brain dumb on the stuff that you're telling me.
I can't give you legal advice.
I don't want
On more than one occasion, I have told you if you want to file a motion to attack the validity of the underlying judgment, you can do that. That's all I
Okay,
can tell you, sir.
Okay, so I need to file a motion to file a motion
Just say there's
to-
something wrong with the underlying judgment, but you can't do
to-
that with the objection to garnishment. Thank you for coming in, sir.
All right, thank you.
We're off the record. Yes. Good morning.
Good morning, Your Honor.
Mr. Chisholm, what file do you have?
Judge, we are here on the reliable auto financing Kevin Green motion for summary disposition. This was a,
Yeah, I know it. Okay, I'm gonna put you back in the waiting room. I got some objections to garnishment I need to take care of, and I'll get to you soon.
thank you, Your Honor.
Can you hear me? Hello?
Yes.
All right. Mr. Johnson, we're waiting for him to join us. I let him in a minute ago, but he hasn't gotten here yet. So let me try getting him again. Okay. 18,561. Having trouble having him join us today.
Yeah, I apologize, Judge. I'm sorry about that.
It's all right. Technical things happen. It's not nobody's fault. All right, we are on the record. This is case number 18160-561. The case is entitled Velocity Investments versus DeAndre Lowe. Date and time for objection to garnishment. Appearances, please.
Good morning, Your Honor. Brad Johnson, P75416 on behalf of the plaintiff.
And what is your name, sir?
DeAndre Lowe.
Sir, you are the moving party. What is the basis of your objection to garnishment?
I object to this because I wasn't timely served, and also object that I did not take this loan out.
All right, you weren't timely served with what?
The notice that they was placing this garnishment on me.
Okay.
I was never served that.
Okay, Mr. Johnson.
Your Honor, if he wasn't served with it, how is he objecting to the garnishment? And as it relates to the underlying loan under MCR 3.101K, it's an attack on the underlying judgment, which is not allowed in a garnishment proceeding. And we
Okay.
did send a letter to Mr. Lowe at the PO Box in Garden City on November 1st, 2022 with the tax garnishment.
Anything else you want to tell the court, Mr. Lowe?
Yes, when this loan was taken out, I was incarcerated, so there's no way I took the loan out.
All right. In regard to your objection to garnishment, Michigan Court Rule 3.101K specifically provides that you cannot use the objection to garnishment as a method of attacking the validity of the underlying judgment. Therefore, that objection to garnishment must be denied. You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. In addition to your objection to garnishment, you filed a motion to set aside default judgment. Mr. Johnson, did you get that motion?
I did not receive that, Your Honor. I'm sorry.
Okay, well, I can't decide that if you haven't. What I'll have to do then, I'll deny the objection to garnishment. Mr. Lowe, if you're going to serve a motion, you must serve the opponent for the other side. You didn't do that here. He has a right to have a notice and opportunity to be heard. So what I'll do, excuse me, I thought I was talking.
I'm sorry.
I swear I was talking. So what I'll do is I will set a separate date for hearing on this objection, on this motion to set aside default, so that you can serve a copy of that on Mr. Johnson. You have a copy of your motion?
Yes.
You must
The
serve.
court served
No, sir. That is not the court's business. That is not the court's job. Court's job is to file and calendar. It is the obligation of the litigant. If you want to represent yourself and act as your own lawyer, you have a right to do that. But that doesn't change the court's duties. It is not the obligation of the court to serve your motion on the opposing party. That is your obligation and no one else's. So let's calendar your motion to set aside default judgment. Today is January 25. It's gonna be 18. 24. Let's get you a date for that motion. We'll do it February the 8th. It'll be a Wednesday at 10 o'clock like today. So what you need to do. What you need to do on this, Mr. Lowe, is you need to serve Mr. Johnson with a copy of the motion that you filed to set aside the judgment. I will send out to you guys today an order denying the objection to garnishment. Mr. Lowe, you have 21 days from today to perfect your appeal in regard to that. I will talk to you guys 2 weeks from today in regard to Mr. Lowe's motion to set aside. You again must serve Mr. Johnson and file proof of service with the court. Thank you, gentlemen, for coming in. We are off the record.
Thank you.
Thank you.
Hello,
Yes,
what is your name?
my name is Jamila Williams.
All right, we are on the record. This is 20143-118. Auto Advance of America versus Jamila Williams. Date and time for objection to garnishment, your appearances.
Morning, Your Honor. May it please the court, Keith Nathanson, P41633, on behalf of the plaintiff.
And what is your name, ma'am?
My name is Jamila Williams.
You are the moving party. What is the basis of your objection to garnishment?
Because back then the owner of the company basically told me that he don't want my business, he don't want my money, and I'm not getting my car back. So I don't understand why he trying to garnish me if he deliberately told me that. I also let them know then when we were on the phone that this conversation is being recorded, because before I had started recording him, he cussed me out and hung up on me. So I called back and made sure I got everything he was saying to me on record.
Do
So
you have any other basis for your objection to garnishment?
when I tried to get my car back, that's what he told me. So I don't understand why they want to garnish me if he wasn't going to allow me to receive my car back.
Mr. Nathanson.
Thank you, Your Honor. Well, under 3.1010, an objection to garnishment cannot be used to collaterally attack the basis of the judgment. I would also note for the record that the copy that I received of the MC49, paragraph 1, there is none of the enumerated reasons for the objection to garnishment have been checked. We just asked the court to deny her objections as they are improper before the court.
All right, Ms. Williams, we're filing this record indicates that on February 24th of 2020, you were personally served with summons and complaint You failed to file an answer, and a default judgment was entered against you on May 12th of 2020. Under the Michigan Court Rule 3.101K, not over.
Oh, I'm sorry, Your Honor. My error, sorry.
Under 3.101K, you may not use the objection to garnishment, which is the only matter before the court today, as a method of challenging the validity of the underlying judgment. Having failed to state a valid objection to garnishment, court must deny that objection to garnishment.
Well, I haven't
Excuse me,
received,
ma'am, I'm
I'm
talking.
sorry. I'm sorry.
You have an absolute right to appeal my decision. That appeal must be perfected within 21 days of today in the Wayne County Circuit Court. Thank you for coming in.
All right.
You're on record.
All right, thank you, Your Honor. Have a good day. Stay safe.
We'll send out an order to you both today.
Very good. Thank you very much.
Have a good day. Thank you for coming in now.
What do I supposed to do?
If you want to appeal my decision, ma'am, you have 21 days to perfect your appeal in the Wayne County Circuit Court. Thank you for coming in. Hello,
Yes,
what is your name?
Kevin Green.
Kevin Green?
Yes, Kevin Green.
Okay.
Okay,
I have Mr. Chisholm and we can begin.
okay.
We are, well, can you hear me, Mr. Chisholm?
Good morning, Your Honor. Yes, I can.
We are on the record calling 22190-626 Reliable Auto Finance versus Kevin Green, adjourned date for motion for summary disposition. Appearances.
Good morning, Your Honor. Jeremy Chisholm, it's P74670. I'm the attorney of record for the plaintiff.
And your name, sir?
Kevin Green.
Okay. Mr. Chisholm, your motion.
Your Honor, plaintiff filed this motion after going through the discussions with the defendant, the pretrial conferences, requests for admissions and such. This is a auto case. The plaintiff holds a retail installment contract. The defendant stopped paying on that contract. There's a balance remaining. The car has been concealed. The plaintiff has not been able to recover it after numerous, consistent and constant attempts to recover it. So they brought the present case to recover the balance due and owing on it.
I object.
Excuse
I
me.
object.
Excuse me.
I tried to give this
Do not,
car back.
excuse me. You hear my voice?
Yeah, I do.
If I'm talking, you're not. Do you understand?
Yeah.
I'm going to let him finish and you're going to be able to say whatever you want. Please do not interrupt again.
All right, thank you.
Mr. Chisholm, continue.
Judge, the plaintiff has in there through the motion and the initial filings of the case shown the balance due and owing on that car. So the present motion for summary disposition was filed. Plaintiff doesn't believe there's been an adequate answer filed by the defendant.
Mr. Green, your response.
Yes.
Say anything you choose.
I was taking advantage from the beginning. I understood the price of the car to be $11,688. I had a card explaining my condition and gave it to Gary, the salesman at the car place. And I could not and would not make any monetary decisions without a sound-minded person, which was my brother. Okay. And my brother went out to smoke a cigarette because Gary said it would be okay for my brother to speak for me. But my brother went out to smoke a cigarette. By the time he came back, I had already signed the paper. because Gary was talking fast and yada, yada, yada. So I signed the papers. And I always, in 36 months, I paid you guys $18,646. Okay, but then now they wanted me to pay. It was $18,249 that they wanted. Okay, and like I said, in 36 months, I paid them $18,646. But now they said I got to pay 42 for 42 months because of the contract. I don't think that was fair.
Okay.
Because I already paid over the price that they wanted. And I gave them a Chevy Impala on top of that.
All right, Mr. Chisholm, your response.
Judge, paid to the contract is in fact a 42-month contract. Paid to date, as I believe was attached to the motion, $15,376.22 was the amount paid to date. Contract obviously was for more than that. Additionally, since no payments have come in, interest has occurred since that time, but the plaintiff has voluntarily waived that. The plaintiff's assignor, I obviously don't have any knowledge of what transpired with the dealer prior to Reliable Auto Finance being assigned the contract. But I will say, Judge, this has gone on, as Mr. Green points out. He certainly didn't object to anything that happened on this for 3 years, and still to this day possesses the vehicle. So
All right.
I'm
prepared to rule. Thank you. This is a motion under MCR 2.116C10, claimed by the party. What did you want to say, sir?
Yes, I paid them $100 over the monthly cost for $420 so I can pay it off faster.
All right. Court's prepared to, as I indicated, to rule in this matter. This is a motion under MCR 2.116C10. The plaintiff claims there is no genuine issue of material fact, and that the plaintiff is therefore entitled to judgment. In construing a motion under MCR 2.116C10, the court is obligated to be generous in finding that there is, in fact, a dispute, a genuine issue of material fact, or it's required to be liberal in finding the existence of such a fact. However, the rule is also governed by MCR, the motion is governed by MCR 2.116G4, and I'm quoting, a motion under subrule C10 must specifically identify the issues as to which the moving party believes there is no genuine issue as to any material fact. When a motion under subrule C10 is made and supported as provided in this rule, an adverse party may not rest upon the mere allegations or denials of his or her pleadings, but must, by affidavit or otherwise provided in this rule, set forth specific facts showing that there is a genuine issue for trial. If the adverse party does not so respond, judgment, if appropriate, shall be entered against him or her. The answer that was filed here on behalf of the defendant, first of all, there is no affidavit as required by the court rule. Secondly, in his answer, defendant admits the existence of the signed contract. The court finds there is no genuine issue of material fact in this matter. The court is going to grant motion for summary disposition in favor of the plaintiff. Mr. Green, you have an absolute right to appeal my decision. That appeal may be perfected within 21 days today in the Wayne County Circuit Court. Mr. Chisholm, I look forward to your order under the 7-day rule. Thank you both for coming in. We are off the record.
Thank you, Your Honor.
Thank you, sir. Hello,
Hello,
what is your name?
Lakeisha Williams.
I think I have the other side.
I'm sorry.
I said, I think I have the other side. I'm trying to get him in here. We can get started on your file, ma'am. Mr. Kirschenheider, what file do you have today?
Good morning, Honor. I have last three are 002.
Okay, we have everybody then. This is file 21-180-002, Credit Acceptance Corporation versus Lakeisha Williams. Date and time for objection and garnishment. Your appearance.
Yes, good morning, Honor. Michael Kirschenheider for the plaintiff, P75722. How are you?
Oh, I'm fine, sir. And could I have your name, ma'am?
Lakeisha Williams.
Ms. Williams, you are the moving party. What is the basis of your objection to garnishment?
Because I feel, one, that I don't owe that amount, and two, the correspondence haven't been rapidly. I only received like 2 correspondence, maybe 3, because I responded to one and then I didn't get anything, and then I responded to the second one. So the correspondence hasn't been that accurate, and the amount that they stating that I owe is not accurate. And it looks to be that they already sold that account for a third-party collection.
Mr. Kirschenheiter?
Your Honor, in response, I would indicate that defendant appears to be attacking the underlying judgment, which is not allowed under the court rules. Also, just so the defendant is aware, my firm, Weber and Olstein, while they are servicing the account, Credit Acceptance is still the plaintiff. We represent them. We have not purchased this account in any way. But as to the objection, I do not believe it's a valid objection.
Yeah.
I feel it's a fair objection because if you look it up, it has been sold to a third party.
Well, ma'am, do you have any other basis other than that you say was sold to a third party?
And I don't feel like I owed that amount that they stated. So therefore, I don't feel like I should be trying to get garnished.
All right, ma'am, let's review the procedural history here. That might be some help to you. On
That's fine.
March 19th, 2022, you were personally served with summons and complaint. You filed an answer, and the court set the matter for pretrial on June 6th of 2022. On June 6th of 2022, you failed to appear. A judgment was entered, a default was entered at that time. Subsequently, on that's August the 18th, 2022, the judgment by default was entered. Under Michigan Court Rule 3.101K, you may not use the objection to garnishment to say there's something wrong with the underlying judgment. Having failed to state a valid objection to garnishment, court must deny that objection. You, of course, ma'am, have an absolute right to appeal my decision. That appeal must be perfected within 21 days today in the Wayne County Circuit Court. Court will send out to both of you an order denying the objection to garnishment. Thank you both for coming in. We are off the record.
Thanks, Judge. Have a great day.
You too. We are on the record calling file number 10128-753. The file is entitled Community Choice Credit Union versus Gary Ward. This matter is before the court today on an objection to garnishment, scheduled to be heard at 10 o'clock. It's now after 10:30. Neither party has appeared. So the court is going to deny the objection to garnishment. Thank you. We'll conclude the morning call. Wait, there's somebody here. Let's see what this is. Hello?
Yeah,
Who is this?
Lakeisha Williams.
Yeah. Ms. Williams, I made my decision. Your remedy, ma'am, is an appeal. You have 21 days in the Wayne County Circuit Court to perfect that appeal. Thank you for coming in. I can't talk to you ex parte. The other side is already gone.
I just had one question.
Ma'am, I can't have a discussion with you without the other side here. They've already gone. Thank you for coming in. All right, we're back on the community choice matter. The objection to garnishment will be denied. Neither party